Good day everyone. Today I am going to report about Chapter 5, Rule 3 to 4. Rule 3, the composition of arbitral tribunal. So, it consists of one or more arbitrators that adjudicate and resolve the dispute and provide an arbitral award. The Indian Council of Arbitration has provided a set of rules known as the Rules of Arbitration that are to be abided by the parties undergoing the arbitration process as well as the arbitrators. In Article 5.9, Rule number 3, number of arbitrators. The parties are free to determine the number of arbitrators. Failing such as determination, the order of arbitrators shall be 3. And in Article 5.10, Rule number 3, appointment of arbitrators. Any person appointed to serve as an arbitrator must be of a legal age, in full enjoyment of his or her civil rights, and knows how to read and write. No person appointed to serve as an arbitrator shall be related by blood or marriage within the 6th degree to the either party to the controversy. No person shall serve as an arbitrator in any proceeding if he or she has or had financial, fiduciary, or other interest in the controversy or cause to be decided, or in the result of the proceeding, or has any personal bias which might prejudice the right of any party to a fair and impartial awards. No party shall select as an arbitrator any person to act as her champion or to advocate his or her cause. In Article 5.11, grounds for a challenge. When a person is approached in connection with his or her possible appointment as an arbitrator, he or she shall disclose any circumstance likely to give rise to justifiable doubts as to his or her impartiality, independence, qualification, and disqualifications. An arbitrator from time of his or her appointment and throughout the arbitral proceedings shall, without delay, disclose any such circumstances to the parties unless they have already been informed of them by him or her. A person who is appointed as an arbitrator, notwithstanding the disclosure made in accordance with this article, shall reduce the disclosure to writing and provide a copy of such writing disclosure to all parties in the arbitration. And in the Article 5.12, challenge procedure. The parties are free to agree on a procedure for challenging an arbitrator, subject to the provision of paragraph C of this article. And failing such agreement, a party who intends to challenge an arbitrator shall, within 15 days after becoming aware of the constitution of the arbitral tribunal, or after becoming aware of any circumstance referred to on paragraph B of Article 5.11, grounds for challenge, send a written statement of the reasons for the challenge to the arbitral tribunal. Unless the challenged arbitrator withdraws from his or her office or the other party agrees to the challenge, the arbitral tribunal shall decide on the challenge. In Article 5.13, failure or impossibility to act. If an arbitrator becomes de jure or de facto unable to perform his or her functions or for other reasons fails to act without undue delay, his or her mandate terminates if he or she withdraws from his or her office or if the parties agree on the termination. Otherwise, if a controversy remains concerning any of these grounds, any party may request the appointing authority to decide on the termination of the mandate, which decision shall be immediately executory and not subject to the appeal or motion for consideration. And in the Article 5.14, appointment of substitute arbitrator, where the mandate of an arbitrator terminates under Articles 5.12, the challenge procedure, or Article 5.13, the failure or impossibility, or because of his withdrawal from office for any other reason, or because of the revocation of his mandate by agreement of the parties, or in any other case of termination of his or her mandate, a substitute arbitrator shall be appointed according to the rules applicable to the appointment of the arbitrator being replaced. Now we proceed the Rule 4, the jurisdiction of arbitral tribunal. In Article 5.15, competence of arbitral tribunal to rule on its jurisdiction. When a demand for arbitration made by the party to a dispute is objected to by the adverse party, the arbitral tribunal shall, in the first instances, resolve the objection when made on any of the following grounds. 1. The arbitration agreement is inexistent, void, unenforceable, or not binding upon a person for any reason, including the fact that the adverse party is not privy to said agreement. Or number 2, the dispute is not arbitrable or is outside the scope of the arbitration agreement. Or number 3, the dispute is under the original and exclusive jurisdiction of a court or quasi-judicial body. And that's all. Thank you.